समझ गया दिल, ये भी अब तो समझाने से। लड़ी जाएगी ये लड़ाई अब तो आशियाने से। मिलकर नहीं अलग अलग लड़ना है हमें। गौर से सुनिए दोस्तों, मिलकर नहीं अलग अलग लड़ना है हमें। मैं लड़ता अपने मैं लड़ता अपने, तुम लड़ो अपने ठिकाने से। घर में हो तुम इसे कैद ना समझो मेरे यार। घर में हो तुम इसे कैद ना समझो मेरे यार। कट जाएंगे दिन ये तेरे मेरे मुस्कुराने से। Hello everyone, I am Sahil Chopra, part of Lawyers team. Welcome you all to the panel discussion organized by Lawyer and Lawyers Club India on COVID-19 versus corporate, a legal analysis. As you know, the current situation has impacted businesses across the globe, and we are privileged to have such an distinguished panel with us today to give best insight on the topic. So, without wasting much time, I would like to state the rules for the session. Everyone will stay on mute and off videos except the panelist. Questions to be submitted via chat window only and will be put up during the Q&A session. I hope this session will be able to solve your queries raised due to the pandemic. Now, I welcome Ms. Purnima Khanna to take the discussion forward and introduce the panel.
Hi everybody, this is Purnima Khanna from the Lawyers Core team. In today's scenario, when tech has come out to be the most evident solution to the pandemic, we are here to utilize the idea to its utmost. Lawyered is a legal tech startup designed to change the way people interact with and within the legal industry. We strongly believe that law symbolizes power, righteousness, and equality. We help you build relations with and within the legal industry throughout your professional and personal journey. Lawyers and Lawyers Club of India jointly present this interesting discussion on COVID-19 versus corporate. I would also like to introduce our panel of speakers today. Our first panel of speakers is Mr. Pawan Singhal, presently associated with Ather Energy, an intelligent EV company, as Chief Legal Officer. He has rich and versatile legal experience of more than 25 years, including General Counsel role for over 15 years. His associations include 3M, AstraZeneca, Max Bupa, Intel, MMTC, and others in a wide spectrum of industries. Pawan was also named in GC Power List India 2016, released by Legal 500. Also named as India's finest in-house counsels at ICCA Annual International Summit in 2016. Thank you, Mr. Pawan, today for being here with us. Our next panel of panelist is Advocate Aaron Solomon, a name synonymous in itself. Aaron Solomon is the managing partner of Solomon & Co., a full-service 65-member law firm with offices in Mumbai and Pune. Aaron has been in active practice for over 25 years. He specializes in transactional work, including mergers and acquisitions, joint ventures, exchange control regulations, competition law, banking, investment funds, private equity, and securities law. He has a hands-on approach and has assisted several landmark domestic and cross-border transactions and legal proceedings over his career. Aaron qualified as an advocate in the year 1995 and was ranked first in All India Solicitors Examination in 1996. Thank you, Aaron, for being with us today. Our next panel of speaker is Hitesh Mehra, currently heading the group legal function for a listed IT product organization with global footprint. A general counsel with over 20 years of holistic industry experience across reprographics, automotive, electronics, telecom durables, healthcare, insurance services, consulting services, automation, telecommunication, software products, and the list goes on. But his focus area is technology industries. Mr. Hitesh has previously held general counsel position in Alcatel, Lucent, and Ernst & Young. Welcome, Mr. Hitesh Mehra, today with us. Our next panel of speaker is Mr. Mukul Shastry, General Manager, Adani Group, primarily handling the legal portfolio of Ports and Logistics Division, also advising corporate mergers and acquisitions. Prior to this, he has been heading legal division in KEC International, also worked for considerable time as legal counsel in Reserve Bank of India. He started his career as an advocate and practiced before Rajasthan High Court for 4 years. He has also been assistant professor at NLU, Jodhpur between 2006 and 2009. He's adept in business strategy, corporate mergers and acquisitions, claims management, litigation management, legal processes, arbitration, including international commercial arbitration, compliances with RBI, SEBI, MCA, rules and regulations, trade and competition law, banking laws, forex laws, and general corporate laws. Indeed, Mr. Shastry, we know you are a doctor. Thank you for being with us today. Our next panelist is Advocate Sanjiv Dagar. He has been managing corporate advisory, consultation, and litigation verticals for Legajoist law firm. The firm has the privilege to serve big brands in every possible sector, including e-commerce, banking and finance, software, technology, food and beverages, pharma, and hospitality. Sanjiv is a corporate, business, and strategist lawyer with tremendous experience in litigation, advisory, and contract management. Sanjiv's role is to mentor Team Legajoist and to advise in strategy, litigation, and other legal transactions. In addition to steering cross-border corporate governance and international legal transactions for clients. Also to say, he is steering his way in the hardcore legal industry. Thank you, Sanjiv, sir, for being with us today. Last but not the least, Mr. Himanshu Gupta. He is known as a result-oriented, decisive leader with a knack for identifying market, industry, and customer needs. Himanshu seamlessly combines his successful corporate, domain, and technology expertise to the exciting growth story of LAWyersclubindia. He has over 21 years of diverse experience in managing technical and commercial function roles, including last 13 years exclusively in the legal tech domain, serving the legal fraternity. His expertise is at innovation, product development, commercial execution, keeping customers' needs paramount. If you haven't noticed, he's running for the CEO of the year as well. Guys, jokes apart, he is not running for any competition. Welcome, Mr. Himanshu Gupta. I thought that I could only have fun with him. I hand over the discussion to you now with all the panelists.
Thank you, Sahil, and thank you, Purnima. I hope I'm audible to all. Yeah. Okay, let's get started. So I was thinking this morning that while we were all busy in reaching the skies in our own self, and here comes an unknown virus changing the growth trajectory of businesses across the globe, sparing none. And suddenly we all start focusing on bare necessities and trying to figure out ways to bring back the life in our businesses. So while it is necessary to maintain personal hygiene for sure, to avoid the further spread of this COVID-19 virus, the need of the hour is to look at how it has impacted the businesses and the legal way out. Now, carrying this sentiment, I think we are holding this panel discussion. And my first question is for Mr. Pawan Singhal. Mr. Pawan, if you can just help us understand what help is available for startups and SMEs whilst the world is on hold tackling COVID-19, and what can they hang on to so as to keep themselves relatively stable? If you can just throw some light on it.
Sure. So first of all, thank you, Himanshu, for this opportunity, and thanks to the lawyer for organizing this webinar on a topic which is absolutely contemporary and which has impacted everyone. And good afternoon to all the other panelists and folks in the audience. So this is something which like unprecedented and which has this pandemic has impacted the entire world. Even the most powerful countries in the world have come down on their knees to deal with this unprecedented situation. And yeah, India has not been an exception, but I believe the way India has handled it it is tremendous considering the size of population we have, the ecosystem we have, and the steps which have been taken over the last 2 months have really helped us keep this pandemic under control as compared to if you look at the developed countries, look at US. So there the numbers are very large. Globally, 4 million people plus have been impacted. 300,000 plus casualties have taken place. So from that perspective, yes, India has been on a strong footing in terms of dealing with the pandemic. Yeah, and this pandemic has impacted not only startups, not only SMEs, but the entire world, the entire corporate world, the entire humanity, I would say. And everybody has experienced it. I would say for the first time, because in our lifetimes we have not experienced these kind of situations where the entire world, virtually the entire world, is locked down, and we are all confined to our homes or in self quarantine, as we may say. So coming to the point of what help is available for startups and SMEs, I can let me start with the startups. For the startups, I won't say in so many words that there has been any kind of help. When you say help, it is, I would constitute it in terms of support from the government in terms of maybe financial help, in terms of helping them in running their businesses, or in terms of continuing their existence. And from that perspective, at least the startups have not been on a very receiving side of the financial assistance. Yes, over the last few days, because of this new stimulus which has been announced, there are quite a few things for the MSMEs. But if you look at the startups which do not fall in the category of MSMEs, literally there has not been much for them, and they have been left to be self-reliant. And what is today the word, the tagline is become be Atmanirbhar, and so that's what we are supposed to be. Yeah, the challenges, the impact has been very, very severe in terms of business impact, in terms of managing our supply chain, in terms of managing our cash, because the startups are always running on tight cash positions. So cash preservation, optimization of cash resources, fundraising activities, everything has got impacted. And employee retention, motivation has also become very, very important. And especially in a scenario when the funds are in a crunch, you're not able to raise new funding. Even if you're in the process of raising funding, those have been put on hold. So unlike large corporations where there are sufficient cash reserves to deal with these kind of situations, startups are in a relatively precarious situation, I would say. So in these kind of times, what keeps us going is to stay focused on what we are doing, what our objectives are. Yes, we got to be very agile to be able to adapt to the new scenarios, and of course look for opportunities wherever we can, even in these challenging times, and adapt ourselves to that, and don't miss out on any such opportunities. Stay proactive, be transparent with your employees, keep them motivated, because if you look at the startup culture, or even in the Indian environment, not many people are used to working from home. Not many people are used to these kind of operating environments where you are spending all your day on the calls or your virtual meetings, etc. And they feel quite demotivated when they have to deal with the work on their own, and it is very important for the leaders to make sure that their employees are engaged, motivated, and energized all the time, so that you are able to drive your agenda, you drive your objectives, even if your business may have slowed down. But there are a lot of back-end work which keeps happening in terms of future planning, future engagement, and dealing with the current situations. So this is so employee engagement and motivation becomes very important. And likewise, the how do we manage our resources, because we are sitting on limited cash, so we got to be very, very frugal, very intelligent in managing our resources. So this is how you hang in there. You continue to run your business, your activities, if not the business, and stay optimistic and positive about things will change and we will be back soon.
Yeah, thank you so much, Pawan. So I think, as you rightly said, the gist is obviously the new buzzword Atmanirbhar, that everybody is like taking in the right spirits as well. And also necessity is the mother of invention. I mean, nobody had thought of working in this work from home. Earlier, it was considered as a privilege to the select few. Now it is a mandate. I recently read that even companies like Google have mandated work from home for the lifetime for some of the employees. And that's the new normal, as we may call it. Thank you for your responses. I would like to shift to some other aspects of this impact of COVID-19 pandemic. I would like to ask Mr. Aaron Solomon, specifically regarding the contracts. So parties may also cite COVID-19 as a basis for renegotiation of price or other key contractual provisions. Will it be fair to the other party, and whether the obligation to make payments under the contract can be delayed or withheld due to lockdown? That's one of the most commonly asked questions.
Thank you, Himanshu. So I think the jury is still out, as we say, in terms of whether the pandemic and the lockdown will provide a party with an ability to walk away from a contract. It depends upon evolving law. It depends upon the wording of the contract. But I think what we have seen is the courts are being extremely sympathetic in view of the difficulties faced due to the lockdown and the pandemic. They're being extremely liberal in granting moratoriums to lenders, to debtors in multiple different ways. So the reality is a delay or a renegotiation or a possible termination or reworking of a contract could be or not be as struck down or frowned upon by the court as it would be in a normal time. That possibly opens the door to a contracting party wanting to renegotiate a contract. I think there have been studies as well that I think from 100% of the contractual disputes, only less than 10% actually reach the court. Less than 30% actually get to the stage of a legal notice. And most contractual disputes are settled by the parties. So very often, one of the two parties to a contract wish to use this as an opportunity to get to a different or a better deal without there being an expectation or a wish to actually end up in the court. Now, how would you deal with that if you're on the opposite end of a contract? To my mind, there is a new business climate out there. Even once the lockdown is over and we get back into the real world, there is a different set of demands, expectations, opportunities out there. Contracts are legal documents built upon a certain economic and commercial environment. There is a huge change and a sea change between the current environment and what existed at the time the contract was entered into. So if a party approaches you to renegotiate a contract, to my mind, to some extent, it is justified. But two, you need not necessarily look at this as something bad. When you renegotiate, both sides to a contract are renegotiable. There could be things, which you realize after being in a contract for a few months, which you could do better, which you could do differently. Your own business has changed as well. The market has changed as well. Second, a renegotiation puts no obligation on you to accept a renegotiated proposal. You always have the ability to walk away. And if you do walk away, if you do say no, the fact that the other party started renegotiating improves your ability to either insist upon the contract and claim a breach by the other party, or to terminate the contract and to find another supplier or another buyer. It improves your position before the court or outside the court if you do walk away from the contract. So negotiation is something which I feel would be the norm, but it's not necessarily a bad thing.
Certainly.
Coming to
So, yeah, another question so attached to here.
Should I do the second question?
Yes, please.
I mean, your question was, does the current lockdown and the pandemic justify a delay or a failure in payment? Yeah. Again, to my mind, failure to pay, no. A contract is a contract. All dues are payable. A lockdown, I mean, we will possibly discuss later on a webinar the impact of a force measure. But unless a force measure applies, there is no, excuse for payment. Even if a force measure does apply, the law provides that you're entitled to be paid for value received. So even if the contract goes away, if you've actually done a delivery, if you delivered an asset, if you delivered goods or services, you're entitled to be paid for it. Yeah. When it comes to deferment, I think the courts are locked down as well. To a large extent, hearings are few and far between. They are being liberal in terms of time frames, like I said earlier. So I think delays in payment are being looked up, are being excused. Courts are wanting it to be reasonable. So delay can be considered to some extent, but failure, no way.
Thank you so much. And one more related question is, I mean, the old erstwhile way of signing the contracts have been physical signing. So what are the new ways that parties can enter into new contracts owing to the lack of postal services and lockdown?
So I think despite the lockdown, I mean, our firm has been completing, several very large transactions, including, cross-border investments, fund investments, on contract adjustments. So contracts are being signed even with people at home. Electronic contracts are enforceable and admissible in evidence under 10A of the Information Technology Act. An electronic contract includes email messages, WhatsApp messages, SMS, of course, in the old world, fax, scanned copies, of course. It does not substitute the need of a physical contract. So I would certainly encourage that once the lockdown is over, parties do continue an electronically shared document into a signed, stamped, delivered contract. But given the current lockdown, people are completing and funding transactions, including financing transactions, based on electronic contracts. A couple of further thoughts is in terms of emails. It'll be great if you can attach a scanned copy of the entire contract with it, because the detail or entire written contract gives, an email cannot substitute. That is one. A couple of other initiatives is, again, copying many of the IT companies, like some of my learned friends on the panel would recommend. Shrink wrap contracts, website contracts. If you're sending an email, you can possibly attach a document to it, which is with an accept or reject button to say to proceed with this, please click accept. If you're delivering a document or a product, adding a shrink wrap contract to it to say by opening this parcel, you will be deemed to be accepting the enclosed terms and conditions. So a couple of additional steps which are being used could be used more commonly now to deal with the challenges imposed by the lockdown.
Fantastic. Thank you so much. Now I would like to ask a question to Mr. Hitesh Mehra. So against the backdrop of COVID-19 outbreak, why is it critical that the board of directors understand the scope and extent of their statutory and fiduciary duties? And what will be the main duties and responsibilities of the Pullman, the legal and general, in various companies? Mr. Hitesh, shall I repeat the question?
Yes, Himanshu, I just reconnected. I'm sorry. Please go on.
Okay, so I'll just repeat the question. We're shifting from the contractual obligations answered by Mr. Arun. So I would like to ask that against the backdrop of the COVID-19 outbreak, why is it critical that the board of directors understand the scope and extent of the statutory and fiduciary duties, and what will be the main duties and responsibilities of the Pullman in various companies?
Firstly, COVID-19 is a black swan event. It's something which in risk management it's not possible to predict or to model for in a normal uh, business as usual environment. So the approach of the board first has to be to, never let a good crisis go waste, and to see an opportunity in this. So most boards are working on various modelings, most of them built around uh, how does one uh, take advantage of this, and there are various short-term, medium, and long-term scenarios which the board has to consider. Many boards have set up a number of specialized committees which are hands-on into activities both at the administrative level and then at the macro strategic level. Uh, and to each industry, the scenario is completely different. For instance, those which are related to travel tourism is completely different. IT and technology is very different. They are seeing most of this scenario as an opportunity, uh, uh, because of the kick which the business environment has now got because of virtualization. Uh, a lot of, I mean, to give you a simple example, even the patent filings have gone up in all the companies, or at least a lot of work has started on that. Even those businesses which weren't thinking very actively on these lines. Uh, uh, Cybersecurity is obviously something which is here and now danger, which is presented by the work from home, virtualized, distributed working environment that we are now in. Uh, it's one thing to put IT layers, but behaviorally to get to get people aligned to. Am I audible?
Yeah, yeah.
Yeah, to behaviorally to get people aligned to the IT security risks that are currently being undertaken with this new work model is another thing that the cybersecurity committees of the board are currently grappling with. Not that these issues hadn't been dealt with, but now the scale has suddenly increased, and the training that behavioral training that people have got isn't adequate. The patches which are being pushed and a number of mitigation measures which are being taken are really not adequate. Of course, other panelists would also talk about the here and now risk of capital allocation and liquidity risk, payroll being one of them, and the entire issue of course, and I mean, I'm just going from one scenario to another because there are a number of them. One important aspect is also succession planning. uh, a number uh, of senior employees, directors, and those in the CXO layer may get affected at some point of time because of this pandemic, and we have to assume that there's not going to be a virus. This virus is going to stay with us for a couple of years, and we and in that scenario, your succession planning becomes another thing which has to be actively looked at by the board and planned for in two layers. We've already seen examples of this in other countries, and I think the realization is now coming to Indian boards as well. um, and of course, I mean, 24 by 7 now, the reopening SOPs, drills, everything which is required on a sustainable basis, start ramping up business, lo- um, your logistic chains, supply chains, to integrate without any further reversals, uh, is 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 one of the big concern of in almost all industries. Technology remains the same because in the technology industry it remains the same because the human resource pool size is very large. Though these industries are more capable of dealing with the work from home and virtualized environment, uh, uh, as other speakers had also commented, we are culturally not inclined, especially if you look at people lower down the hierarchy. They perhaps don't have the wherewithal in their home environment to create a proper virtual office. All these things put together make the entire and make the entire scenario a bit unstable and something which needs to be constantly looked at. Uh, and one more thing from the board's perspective is that virtualized meetings have become the norm now. It's been permitted by law, but that what that also does is practically we need to understand that most of the actual corporate governance happens in the lobbies and in the hallways, in the interaction between the CEOs and the independent directors. All that, the information flow which should happen amongst the directors, it doesn't happen as fluidly except in a one-to-one meeting. So over an extended period of time, the corporate governance would need to evolve, the way the agenda papers are made, the way the information flow has to happen, the way agendas are set. All that would also need to be re-geared for us to be effective in the corporate governance role, and for all the functional heads to support the board adequately.
Yeah, so I think overall a lot of uncertainty is there. So I think things will start clearing out as people spend more time in terms of finding answers and adapting to the situations if this is going to stay for long. My next question, I think, is for Dr. Mukul Shastry. So this is again related to material advice change. Whether COVID-19 would trigger a material adverse change. How do you tell whether a material adverse change has or has not been triggered?
Thank you, Himanshu. And first of all, welcome everybody. It's an interesting session, and I was listening through. Now, coming to a specific question of material adverse effect. Now, see, generally in a transaction document, we have a very typical clause of MAE, which says that if any ownership of assets or any obligation is such or is affected in such a way that it is impossible or it is very difficult or it materially have an adverse effect on the asset itself or on the obligation of that company, then one of the person can undo the transaction by citing MAC and walk away from the transaction. Now this COVID-19, this scenario whereby there have been lockdown for a certain time, whether this particular situation can be considered as a MAC event or not, though it has to be seen from the wordings of the specific contract. But typically, pandemics are not covered under the MAC clauses. Okay. But then again, coming to the specifics, without going to specifics, coming to the genericity of the topic, now, is this COVID-19 can be said to be a material adverse effect? Now, for this, there is no specific cases as such. But then again, if we see the case laws in historical parlance, especially the Banga case of the Supreme Court, whereby the court said that whenever you have to, and where the court was considering the interpretation of contractual clauses of Section 32 and Section 56 of Indian Contract Act. 32 is on contingent liability and 56 is on frustration. So whereby the court said that the change in circumstance should be such that it is affecting the basic fabric of the transaction or the basic fabric of the contract. If the transaction is affected in such a manner that now it cannot be consummated and it will not give fundamentally, substantially the same kind of advantage to both parties, then this transaction cannot be now considered as consummate or cannot be said to be consummated by the parties because of this change which has happened, which was not within the control of the parties. So the change has to be really substantial, material, and has to hit the basic fabric of the transaction. Now, to run more parallels for whether a MAC event, or whether this COVID-19 can be considered as a MAC event, or whether it should be considered as a MAC event, we'll see a few more parallels. Very interesting on a pandemic matter only, there was a Delaware court case, a US case, which is very similar on this, where the court gave an interesting doctrine. The court says, the Court of Chancery of Delaware, says that whether the test, whether a MAC has taken place or not, is fell off the cliff. Whether because of this impact, whether because of this change that has happened, which was not within the control of parties, whether the business has fell off the cliff, whether the revenues have gone haywire, whether the assets have shattered, whether the basic purpose of doing this transaction has been frustrated, that is the test to decide whether the person can be allowed to walk away from the transaction, citing the MAC event. Now, this is about the generic concept of MAC, and a parallel can be also drawn from the SEBI takeover code. You see, even the SEBI takeover code talks something similar to this, which says that once an open offer has been given, it can only be withdrawn whenever such circumstance exists, whereby the transaction now or the offer now becomes completely baseless, and the parties are allowed to withdraw, or the offer is allowed to withdraw the open offer. So if we draw these parallels, in general, we can say that COVID-19 can only be used as a MAC event if you can prove that because of this lockdown, because of this supply chain disruptions, the entire purpose of doing this transaction is frustrated. On the threshold for doing this is very, very high. This is about the generic MAC event. Now coming to the specific, can there be a specific MAC event because of this pandemic? Generally, again, typically, we don't keep pandemic as a MAC event in any of the transaction documents. But even if it is there, then again, the idea is same, whether because of this pandemic, the impact is such which has materially adverse. This means the asset has been materially adverse, the business, the purpose of the business has been frustrated or not. And there's one more interesting thing, that same test of MAC cannot be applied to each and every transaction. So there is not a single test for all, because there is a possibility that one transaction you are doing the transaction primarily for the supply chain purposes, to take over the supply chains. And if because of this MAC event, the supply chain are disrupted for some time, that doesn't affect much, because once this event is over, you are going to get those supply chains, you're going to get those distributions back, and therefore that transaction cannot be said to be impacted because of the revenue loss of say 20-25%, because you are doing the transaction to take over the supply chain or that logistic part, which was intact, and your plan was for a very longer time. Whereas if the entire idea of taking a particular concern was just to boost your revenues, to have your vertical integration better, for sustaining or taking advantage of a particular situation that has arisen, and because of COVID, the entire thing frustrates you, lose the time value, you lose the basic revenue which you thought by this transaction you're going to generate, then that event can be considered as a MAC event for that particular transaction. Therefore, we have to see it holistically, the purpose, the spirit of the contract, and then see that what that MAC event was written in the contract, and whether this pandemic can be classified as one event which has materially impacted the transaction in such a manner that the entire purpose of this transaction is frustrated. So that is what I think will be the impact of how we should see whether COVID-19 should be treated as a MAC event or not.
Thank you so much. Thank you so much for the insights on MAC. Am I audible to all? Yeah. So my next question is to Mr. Sanjiv Dagar. So this is related to insolvency and bankruptcy code. Sanjiv, you've been working in this field for quite some time now. So how does this COVID-19 virus affect the insolvency and bankruptcy code 2016 with reference to the suspension of section 7, 9, and 10?
Yeah, thanks, Himanshu. And good afternoon to the audience. See, this is a very disturbing situation in the first instance. this COVID-19 has disturbed everyone to the extent possible. Okay, I have not seen any kind of disturbance in the history in my life, the way which we have been experiencing now. Corporates have been badly affected. Courts are of course not working. It is very disturbing situation for various stakeholders. Although the courts are working through VC, but it is very difficult for so many people to reach out to the court through VC. Like what we understand, what we hear from media is that Supreme Court and High Courts are working, but what about the trial courts? And if you look into the data, you would realize that we have most of the cases in all the trial courts. And what the trial courts are doing, to a larger extent, what the High Courts and Supreme Court is doing, they are taking up extremely urgent matters, only anticipatory bails, nothing else. In High Court, Supreme Court, we can expect that they are taking up some PIL, etc. But I am quite sure that the way we are handling litigation is very pathetic thing. Coming back to NCLT, IBC was formed in 2016. When the law was brought in, we had great hopes, and in fact, it is a established statistics also that IBC has produced good results. We have seen very, a huge amount of recoveries being made through petitions filed under IBC before NCLT. All of a sudden, what I experience is that government is running out of money and government is running out of mind. They have suspended the proceedings under IBC for 6 months. I do not find any logic or any rationale behind it, although the government is saying that we have done it for the purposes of MSME, for small stakeholders who cannot be penalized for the problem of COVID-19. That's why we do not want to, give any problems to MSME. Let me go a little deep into the provisions of IBC. IBC is made only for the purposes of for the companies which are effectively unable to pay debts, and there is a deliberate attempt to delay or default. In case the companies are not having money, then they should be closed down. That is the process under IBC. There are insolvency professionals who would be appointed IRP and RP. They would immediately take over the company. And if there is any intentional delay in payment, then they would make sure that payment should be made. Or in case the company is not having money or company is already running into difficulties, then company should not have any right to continue its operations. That is all about IBC. Now they say that no new petitions will be filed under Section 7, Section 9, and Section 10. Section 7 applies to financial institutions, banks, and NBFCs. And Section 9 is for operational creditors, and Section 10 is for corporate creditors. Now you give me any logic that why proceedings under Section 10 cannot be initiated. Section 10 has nothing to do with COVID-19 problem. Section 9, Section 10, to some extent, I can think that banks cannot take action because there is a problem, financial difficulty is there. But even if that is the situation, I do not agree with this, because what will happen with the past defaults? Government has not given any clarity on this. What will happen on limitation period? You would very well understand that limitation law applies to IBC proceedings also. If the my limitation is completing within this COVID-19 period, then what will happen? Supreme Court has given a clarification that limitation will not apply in Section 138 matters. It will be extended. But how about the IBC proceedings in NCLT? If I am already about to finish 3 years, or if I will finish 3 years at the end of the expiry of 6 months extension, then what will happen? it means IBC has this notification has completely blocked my way to go to NCLT. That is the problem. So the next is they have extended the limit of default from 1 lakh to 1 crore. That is also unthinkable, unthoughtful idea. I do not find any reasonable logic in this. So I'm sure that it is a very difficult situation, and something should have been done. Like if there is any problem with the companies pertaining to the COVID-19 situation, then the exemption could have been given. Or if the default happens because of COVID-19, then the exemption could have been given. Or to a larger extent, the discretion should be left onto the discretion of the NCLT benches and the bench members. So that is my view.
Thank you so much, Sanjiv. I think that was your experience being talked, where you have seen that the impact is such, and yes, it is debatable for sure. My next question is to Mr. Pawan Singhal. Considering your diverse experience both in corporate as well as your stints with startups, has the impact been different? I mean, when I say impact, the COVID-19 impact been different from that of a startup as compared to a well-established institutions, and how?
Thanks, Himanshu, for the question. And these are not apple-to-apple comparisons. So when you are looking at a startup, which is kind of like of an infant, and an well-established organization, which is like a matured adult, I would say. So the comparisons are very, very asymmetric. So the impacts on that basis are also very different. Of course, you can't make those kind of comparisons. And since I have been part of larger organizations in my previous experiences, and now with the startup as well, and I can see, I can feel the differences in terms of the impact, what we can see, what we can perceive, and what we experience. And there are multiple factors which go behind this kind of impact. Let me start with the size and scale. The startups are just startups. They are in an infancy stage. They are growing, or not even growing, but like trying to establish themselves to be able to come out with what they want to bring out in terms of service or a product or a commodity, right? So they are at a very, very nascent stage of their evolution, whereas the well-established organizations are in terms of size, scale, geographical expansion. They are very large. They have been through all kinds of phases in their life journey. They have been through these challenging times of various meltdowns and crises. But the startups, for most of the startups which are kind of 5 years old, 7 years old, this is something which is out of the blue, which nobody ever thought of. They never bothered about having a business continuity plan or a disaster recovery program or any such thing. So for them, it was like a shock. Whereas for startups, for the matured organization or well-established organization, and particularly MNCs, they are experienced in this, and they have dealt with those kind of situations in the past, and they have the resources to manage their affairs well. So for a startup, it is very difficult when you're smaller in size, you are looking for external funding, you are not having internal accruals, and whatever internal accruals you have, those are impacted by this pandemic. So your internal accruals come down to zero. Your obligations, your liabilities, your responsibilities continue to remain same. New fresh funding is not coming in. So you are in a very, very awkward situation, I would say. And you've got to make sure that your employees are also stay engaged, stay committed, and got to stay motivated. So it is very difficult for startups to manage their affairs with the limited resources they have. And the other key aspect is the maturity of the enterprise and its leadership. if you look at a larger organization, which are global in terms of their presence, they have highly seasoned, matured professionals as part of their leadership teams. Whereas in the startup, it is generally the fresh grads who have come out of the colleges and part of setting up a startup to do something out of the blue or to do something extraordinary, and they have not been through these kind of situations, so their level of maturity, their experience is very different. But they have also because of being agile, have learned very fast. So they have also been able to successfully deal with the situation, though initially there were challenges, but they also learned that how do we deal with this kind of a situation, and they have also learned very fast. They have also been very calm in these turmoil, in this turmoil, and they have been able to take rightful decisions. I won't say that all the startups which were there prior to COVID-19 would remain the same post-COVID. Yes, many might go down, but the ones which have stayed, which have had good leadership, which have been able to adapt to the situation because of being agile and manage their affairs well, they will be the ones who will come out of it flying colors. They will be successful, and these challenges have thrown a lot of opportunities also, to those startups. How to in terms of how to adapt to a situation, how to look for opportunities, what else can be done with what we have, and how do we manage ourselves better. So if you look at the positives, there has been multiple positive impacts also for the startups as well. So from that perspective, yes, startups have their own challenges and they have their own way of handling with it and dealing with those challenges as compared to the well-established organizations. And there have been learnings for everyone in this, even as individuals. We also have a lot of learnings. How do we manage ourselves? How do we start living in the new normal? Where you have to get used to the virtual environment, get the work done as through your teams, manage your teams, and run your show without any significant impact on your efficiency or productivity or deliverables. And at the same time, manage your customers well without getting into any kind of personal interaction or face-to-face interaction with them. So there have been learnings, there have been opportunities, there have been some impacts, of course, but the scales, the magnitude is different for startups vis-a-vis established institutions.
Yeah, I think rightfully put, while big corporates have deep pockets, they are cash rich, the startups have the edge of being agile, so they can quickly pivot and do something. But in both the cases, the customer's persona or the buyer's persona is going to decide how things unfold. I mean, we're just 2 months in the lockdown in India, but globally it has been almost 5 months now. So another couple of months, people start getting used to the new normal, and how their behavior in terms of buying behavior changes will decide the further course of action for every industry, I must say.
Absolutely.
Yeah. Okay, so I'll switch over to Mr. Arun. So we've been talking a whole lot about force majeure. So will COVID-19 give rise to a valid force majeure defense under every contract and in every circumstance, as different contracts and governing laws stipulate different requirements for various situations?
Okay, so I think like I said earlier, there are a few different views prevailing on this. But I think what you need to keep in mind, and I see that's one of the questions which have possibly been asked as well by Amit Rajani, so we can possibly answer it in the same go, is every force majeure clause or even a MAE clause, like my colleague touched upon, has 4 different components to it. First is, what is a force majeure event? The second is, what is the effect of a force majeure event? The third is how do you avail a force majeure remedy? And the fourth is what is the effect of you availing the remedy? So just to touch upon these four things again. The first is what is a force majeure event? The force majeure is floods, pandemics, acts of God, acts of government. To my mind, based upon the notifications and also the sympathetic views the courts are taking, the lockdown, the pandemic would be in the nature of a force majeure event. And in reply to the first question, yes, this is in the nature of force majeure event. But unfortunately, that's not the entire solution. That is just the first step. But then we get to the second step on what is the effect of the force majeure. Depending upon the wording of the clause, some clauses allow you to simply suspend performance. Some allow you to possibly terminate, for example, a lease agreement during a lock-in period. Some allow you to terminate the contract itself. Some would allow you to renegotiate the contract. So then you got to have a look at the contract to see what that force majeure event results in. How do you avail a force majeure remedy? Again, this one is the third point, which is important. Just because you have a force majeure event in the contract as well, and even if it's applicable, does not mean you're entitled to it. Most contracts require to give a notice to the other side saying you're availing the force majeure, and your suspension of benefit or the protection you get will only come into place from the day you issue your notice. So even if you have the protection, it may be important for you to actually issue a notice to the other side saying you are affected, how you are affected, and that you wish to avail the remedy. And a fourth and very important point is to consider is what is the effect the force majeure event will have. You got to keep in mind that a force majeure event does not work one way. It works both ways. If a contract is suspended, all the parties or both the parties to the contract are excused from performance under the contract. Just because you claim force majeure and do not pay does not mean you do not need to pay for goods already delivered. For example, rental contracts. You claim many landlords or many tenants are claiming force majeure, saying we cannot pay rent, but they're continuing in possession of their flats, of their offices. This may allow the landlord to come and say, okay, fine, you do not want to pay me, very good, please give my office or flat back. So you need to consider the effect of force majeure because it could have a backlash on you as well.
Yeah, absolutely. So very bang on. I mean, 4-point answer is fantastic. There is one related question I would like to ask here is, if the contract does not have a force majeure clause, what are, other than doctrine of frustration, can the parties resort to?
I think the contract, the doctrine of frustration would be the typical answer to impossibility of performance. But if you do not seek that, to my mind, it would be delay. There would be, if you take the risk of a default in contract and hope the court will be sympathetic to a default given the current lockdown situation, or you simply delay payment because, and given the extensions and timelines we are seeing across the board when it comes to government filings, tax filings, everything else, I would possibly go out on a limb and say the court would be sympathetic to a delay in delivery due to the lockdown and the pandemic as well.
Okay. Thank you so much, Arun. My next question is for Mr. Hitesh. What are few of the employee continuity risks and concerns that corporates may face, and how can they tackle the same? I mean, not just the corporate, but also the startups are facing this employee continuity risks and concerns. So what are the ways they can tackle them?
Himanshu, unfortunately, this topic is not at the top of the mind in most of the executive circles now, because everyone is tending to think that it's going to be an employer's market for quite some time, and employees are generally insecure about their employment, etc., and everyone just wants to be holding where they are. But uh, globally, because we too and across industries, everyone is is making an extra effort to be in touch with their clients, their vendors, their employees, their subcontractors, the complete supply chain and the complete resource base through which the specific business runs, and to be communicative, to be receptive, and to be flexible. Let us remember, all our contracts have to have a crumble zone. Our contracts are
Yeah.
supposed to be built that way, and that crumble zone is something which has to take some degree of the shock of this pandemic. Every contract has to take some degree of the shock in this, and everyone has to be flexible. Those who are rent seekers in this point of time, be it with respect to their vendors, to their employees, will slowly find themselves isolated, because these are just very short term view, and and in the long term, everyone wants to work with 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 people who are more reliable, who are more trustworthy, and I think that's the approach with which all employers need to have. But unfortunately, like I said, the trend is not such that this is on top of every employer's mind. It should be, it will ultimately be, but another trend is the virtualization trend, because of which you'll find that most of the generalists might have a preference of working out of office, and most of the specialists would have a tendency to work in the virtualized environment and the work from home environment. So they would the specialists would be more marketable. Those ones who are in-house would be less marketable. So the way their remunerations would ultimately gear out would also change. The way employers behave with them would also change. But this will pan out over some time. It's not an immediate risk. That's how I see it.
Yes, yeah, that's very true. I mean, you rightly said that. I mean, most of the companies are. I mean, the situation is being considered as employer friendly rather than employee friendly. But I think the corporations and the companies which are considerate toward employees, their employees are there to stay for the long run. Yeah. So my next question is for Dr. Mukul. So we're talking about employees. So what are the relevant employment law issues relating to health and safety obligations and potential questions around workers' compensation and liability in the event of accidents and injuries sustained while working from home? So this is a very typical scenario. I mean, normally when an employee works out of office, there are many guidelines mentioned, but if he's working from home, so what are the compensation and liability in the event of accidents and injuries sustained?
Yeah, thank you, Himanshu. Before touching upon this, just going back to the previous question regarding the force majeure, which Aaron has very rightly summed up in the 4 points. The question was that if there is no force majeure clause, can there be any other thing other than doctrine of frustration? I think so. We can use change in law also, that if the contract doesn't have force majeure, but if it does have change in law, then any notification issued by the government of India is covered, generally depending upon the contractual interpretation, how the change in law is defined. If that is there, then the change in law also says that if anything has been issued after the bid date or after the contract date or the effective date, and which has caused any financial distress to the parties, the other party has an obligation to ensure that the party is in the same financial implication or financial position as it was had that event did not happen. So I do not know how much that can be explored, but that also a food for thought, that can be one area if there's no force majeure and frustration, because invoking frustration of contract is a very high threshold. So maybe that can be touched upon or can be looked into.
Okay.
Now coming to the specific question of the employees' health, safety, and the liability of compensation on the employment laws. Now there are 2 aspects to it. First is about the compensation per se, because now most of the corporates are not working. There's no work right now going on in the factories, and the employees are working from home or from whatever location they are. They're working remotely. Now in this case, the question is that what kind of compensation and what kind of treatment to be given, or what the law says, or what an employer should do. Now, interestingly, the government of India, they have used the powers under the Disaster Management Act Section 10 and issued order that the workers have to be compensated. But they are the workers, even if they are working or not working, doesn't matter, the workers have been compensated. But the workers they are defined are linked to the Factories Act definition of workers. And most of the employees who are like in the IT company who are working from home or who can do this kind of work may not be covered under their definition of the Section 10 notification issued in India. Now, so far as the employee health safety is concerned, in India, most of these health safety guidelines and the law are covered under various of the labor laws like Factories Act and similar such acts, or the Workmen's Compensation Act. But other than this, many companies have come out with various guidelines. Most of them are known as OSHA guidelines, because these companies have they want to get high certificates. They want to show that they are very concerned about the health and safety, which is one of the most primary factors in becoming a good corporate. And these OSHA guidelines, and they get a lot of certificates from ISO and various OSHA and OSAS certificate, which have even higher thresholds and higher criteria to be fulfilled by a corporate than what is required in the law under the Factory Act, etc. Now, so we have to see this from these two perspectives: what the strict law requires and what these guidelines, which the company itself voluntarily has adhered to, what they require. So far as work from home is concerned, and we see Indian laws as now and the regulations have been issued thereby, I do not think so that specifically for work from home any injury happens that will be covered, because that is outside the factory premise, and that will not be covered under the Workmen's Compensation or under the Factories Act. The only saving grace is that there are getting of case laws under labor law which say that if an employee is injured while purporting or while acting for while discharging his duties towards work, irrespective whether the premise was within the factory or outside, that can be considered as an injury during the work time, and he can be compensated accordingly. And employer has to compensate, and the insurance companies are liable to pay depending on what kind of insurance clauses they have. So we can extend the same analogy here also, that if you're working from home and ultimately you're doing the work for the company and thereby you sustain some injury or something happens untoward happens to you, therefore that kind of compensation should be attracted to you also. But then again, it has to be seen from the touchstone in the laboratory of the courts that whether this kind of argument is a sustainable argument or not. Now, the second aspect to this is about the OSHA guidelines and all that. Now, they are much more stringent and stricter guidelines. And they say that when the employee or when the workman is working for a company, whether you are a principal employer, whether he is a worker directly or indirectly, if the person sustains any injury while he is on duty, now whether he is working irrespective wherever, until and unless you can prove that despite all reasonable precautions and safety measures and despite all those things, it was completely beyond control, like suppose there's an outbreak and a building fell, all that, something like that, then you're not liable. But otherwise, you are liable to those guidelines to pay compensation and accordingly take care of the employee. And therefore, your insurance should be such which covers those kind of clauses.
That's a very, very insightful stuff. I think with more and more companies asking people to work from home for longer term, I think this aspect will also be evaluated and ensure that the employees who are working from home have a conducive environment, which is as laid out by the law. So that's a very insightful point, Dr. Mukul. So my next question is for Mr. Sanjiv. So this is in the supply chain sector. So considering the supply chain disruption caused by COVID-19 outbreak, what will be the implications on contracts?
The supply chain is a very simple thing. What happens? There is a contract, and in the contract, one person is under obligation to supply something, and other person is a recipient. So this is a very practical situation. Now, what has happened is that this pandemic has disrupted the environment, and supplier is unable to supply. That is one thing. So it is very clear that in such a scenario, there could be two situations. One is the force majeure is force majeure clause is incorporated in the contract, or if it is not incorporated, then we have to see section 56 and section 32 of the Contract Act, wherein performance is delayed or performance is hindered in some way, that it cannot be performed, the obligations cannot be performed, then there is no strict obligation in terms of severe consequences. But at the same time, contract cannot be terminated unless until any initiative is taken by any of the parties. If the party says that we do not want to now take the orders and now we terminate the contract, then we have to see whatever has been done in the past. So the recipient is under obligation to make payment of the past supplies received. So the consequences will be in a way that force majeure effectively will come in between, even if there is no force majeure clause incorporated in the contract.
That's very insightful. But Sanjiv, do you foresee a lot of litigation happening, because especially in the supply chain industry, supply chain sector, because of COVID-19 disputes?
Yes, there will be litigation, plethora of litigation. Courts will be flooded with this. In fact, what happens? This is not that a simple situation that I have ordered something and the supplier has not been able to supply the thing. Now there could be a situation when supplier has made something for specifically for me, and supplier does not have any market for that product. Then there will be a situation, because I cannot say that I terminate the contract and you do not supply the material now. So then there will be an ambiguity. Where will the supply go? So the somebody has to intervene, and the court has to decide this kind of situation also.
So this could be quite applicable to a lot of big corporation as well, where they might have put in bulk orders, especially from the Chinese market, and now because of this situation, or maybe not the Chinese but within the country as well, and now because of the situation, they are not receiving the raw materials, or the raw materials received, they're in no capacity to pay. So that can also be categorized in these kind of litigations, right?
And sometimes there is advance payment also made to the supplier. So what will happen to that? So the best thing to understand is to read the contract between the parties. That's why we have always been telling our clients that invest as much time as you can while drafting a contract instead of litigating into the courts. So I think the contract between the parties will give a fair idea as to how the dispute should be settled. Force majeure can play a limited role, but it cannot cover each and every circumstances.
Thank you so much. I think within trust of time, I might not be able to go round off another set of questions, but I have one question which is common to all, which I would like to each one of you to answer specifically in your specific areas. So COVID-19 has affected us all. So it has affected the day-to-day working of corporations. So maybe if you can, in sequence, share and suggest how it has impacted your corporation, and what are the ways by which you are trying to mitigate it, maybe in a minute or two. That will be really helpful for everybody. I would like to start with Mr. Pawan, if you can just share how COVID-19 has affected day-to-day working of corporations, and what are the mitigations that you are taking in your industry, in your sector. Mr. Pawan.
Sure, Himanshu. So as I said earlier, COVID-19 has impacted us badly, and considering the fact that we are one of the startups which is in the manufacturing space, and because of a complete ban on the manufacturing activities, the business has completely gone down, right? And so that is how, like our R&D work, our lab work, our prototype work, everything has come to a standstill over the last 2 months. And that is one major impact on our business. And though it was initially thought to be for a couple of weeks, then it got extended to lockdown 2.0, then to lockdown 3.0, and maybe we don't know about lockdown 4.0. So how it pans out, we need to wait and watch. But yes, in the interim, we have been able to do some kind of an introspection. What needs to be done? How do we look for opportunities during these times, and what else could be done to keep the show running? And how do we prepare ourselves when the lockdown is over and we are back into business? how do we maintain our relationships with our supply chain? How do we maintain our relationships with our vendors, with the customers, and how do we keep working on our expansion plans? So all that work has been going on. So there is no stoppage to that. So we are just waiting for the lockdown to get over, and so that we can execute what we have planned for the last 8 to 10 weeks. At the same time, the fundraising has been a big activity for all the startups, and we were also in the process of it, but because of the slowdown or the COVID, it has slowed down or it has been put on hold, and that is another thing which we need to put on fast track. Though we are doing all the back end work, but that is something which is very, very critical for us from a cash preservation perspective. So except for our manufacturing associates or work employees, all other folks are able to work from home in a virtual environment. They have got used to it. They are being motivated on a regular basis. So we are able to meet all our other deliverables other than manufacturing. And we look forward to manufacturing also to resume very soon, so that we are back into business. And we should be able to do even better than what we were thinking of maybe a few months back, because these 2 months have given us enough time to do some introspection, to find new ways, to look for new opportunities, and make use of those opportunities as soon as we are out of this lockdown. But at the same time, yeah, we are we never know about the wave 2 of lockdown, which may also come in the coming months. So we got to prepare ourselves for that as well. So what if there's a wave 2, and how do we prepare ourselves in a much better way than the wave 1? So those are the kind of things which which are underway, and we are getting ready for the good times.
Yeah, thank you, Mr. Pawan. So the same questions, Mr. Aaron. So if you can just answer how it has impacted the day-to-day working of your corporation.
So thank you, Himanshu. So I mean, of course, we are all working from home, staying safe, but continuing to ensure client delivery from a remote working environment. Our IPR practice is gone fairly quiet. Real estate has been busy, but possibly signs of it going quiet maybe in a couple of months. Litigation continues to be fairly busy, because I think there are so much drafting and preparation even for cases which are 1 or 2 months away from a hearing, in terms of cross-examinations and written submissions and pleadings. Our corporate work, honestly, is as busy as normal. Corporate and finance, funds. So that's the current situation. But the amount of difficulty we are seeing with people are facing, honestly, once the lockdown is over, I see most businesses, one of the first things they're doing is running to a lawyer, because in terms of further financing, further investment, restructuring, debt recovery, government notices, regulatory compliance, HR restructuring. There's a host of things, of difficulties people are facing, in the current situation. So, our challenge is to keep the team together and tide this over, because we certainly see busier days are just a little bit away for us.
Okay. So one related question, Aaron. So, which area of law, would you suspect that will go to maximum litigation post lockdown?
So, I think again, bankruptcy law. Even given the current, environment and the current notifications, the fact is there are many companies who are already in a resolution process and already, got our RP appointed. So all of those ongoing restructurings are being affected, and we will have to go back to court for various clarifications. Of course, new cases as well in terms of bankruptcy law. And the other one, which I think many people are thinking about, is succession planning, or like my colleague mentioned, ring fencing of assets. Because even if many companies see a possible bankruptcy or difficulty a year or two away, taking steps now to secure personal assets and to ensure dependents are taken care of through formation of trusts or other things. That's what I'm seeing a lot of as well. And right now, India tends to be quiet in terms of possibly the new things which anyone can do given the lockdown. But from a cross-border perspective, I think it is pretty much business as normal, because I think many other countries are not in as severe lockdown yet. So I think in terms of cross-border investment, business, I think that continues, at least from a lawyer's perspective.
Okay, fantastic. Thank you so much. So Mr. Hitesh, like the same question for you. So how has COVID-19 affected the day-to-day working of corporation, for your corporation?
So work has been quite crazy ever since ever since February. I think once we really got into the thick of things of following the pandemic. I mean, a lot of time uh, goes into supporting the admin team and the BCP teams, which are working on all the live production environments of the clients. Uh, Crazy amount of reopening of contracts, clients globally going into voluntary insolvency or wanting to take various excuses to get out of contracts, especially in hosted models where we've got upstream and downstream connected contracts. It creates a huge amount of negotiation workload, which is very difficult to handle. On the other hand, we are obviously required to do more with less because the cash conservancy is the first principle in this time. So, the need to be a very nimble function as the legal services team, that flexibility which is required, and down the line, obviously those companies which have teams which are large size will certainly need to relook. There'll be a ten there'll be a tendency towards relying more on automation and smart technology. That has to happen. And you know the and also I think firms which are providing outsource support to in-house legal teams would need to see about their ability to support in-house teams with various gears of rating, and not just the one hourly rack rate and the kind of models where we currently procure. That's one. And then if you look at the footprint of most um, businesses, especially in the technology side, are thinking radically about whether they need such business footprints globally. Uh, a number of offices, their layouts, the number of space that you require, the infrastructure and connectivity which is needed over there, everything is being zero based. And this is besides the negotiations which are going on for waiver and taking the legal safeguards which are provided in various countries. Uh, uh, so waiver, deferrals, protection against vacation, and then terminating a shorter notice, taking the recourse of space utility clause or force majeure clause to uh, to um, uh, to to get out of commitments before the lock-in dates. All those negotiations are going on. The nature and a lot of thought process is going into the nature of workforce itself. That what kind of workforce do we need going forward, given that we are that the times that we are in is going to be the new normal. um, this obviously, currently we know there are a number of global public policies which are working against the gig economy. So there are a number of pulls and pushes. There aren't any clear ideas, but I think the public policies will start to make room for a different kind of workforce, uh, at least in the technology space, and slowly also the flexibility and the which is required for manufacturing to kick in. All that would start. Virtualization of business and how does each industry adapt to it is uh, is is I think throwing up so many challenges for all business managers, including in-house lawyers, that we're just grappling with them. And basically it's a lot of soft play now, but it's taking form. And I think in 4 to 6 months you'll see companies and businesses in their respective industry come with very radical ways of approaching and taking advantage of this environment. That's for my thought.
Yeah, that's just quite holistic answer. Thank you so much, Deshanti. Over to Mr. Mukul. So how it has impacted your corporation and how are you trying to mitigate it?
Yeah, for Himanshu, in Adani right now, what primarily I look is the ports and logistic business, and both the businesses from very beginning were under the essential services, and therefore our operations, especially the ports and logistic and the energy business, were running. So gradually we reduced the staff, and right now we are working with 30% of the staff. But then they were working, and rest of the support services were from home, like legal, finance, HR, IT, and those they were remotely operated. Other business of Adani which are under non-essential services like Adani Realty and others like Wilmar, FMCG production, manufacturing, they were initially closed, and then slowly and gradually the work started there again with a very little staff from 4th May onwards, again with 25%, 20% staff, and but still that is non-functional and non-operational to that extent, and this is how it has been in Adani. But then again, given that most of our bulk work is sports, logistics, and energy, and the gas in which Adani is, that has been more or less functional throughout this period, though with lesser staff.
Certainly. So thank you so much, Mukul. You mentioned that you've been functioning in spite of this lockdown, and I think it is because of this sector, logistics, which is helping the movement of essential services across the state and within the state. So that's quite insightful. Over to Sanjiv. So how it has impacted your business, and what are the next steps and what are the thoughts? Sanjiv, you're on mute. Sanjiv, I think you're on mute. We can't hear you.
Hello. Yeah. Am
Yeah,
I
we
audible now?
Yes,
Okay.
you can.
So Himanshu, what I'm saying is, as everybody knows, litigation services are adversely affected. At the same time, we are continuing with legal opinion advisory, ad hoc advisory, etc. So with regularly with the clients, and as clients, companies are also not, I mean, working to that extent, except IT, telecom, and essential services, food companies, etc. Most of the companies are facing very difficult time, and sometimes it is bad time for the companies which are into routine process, so they have to disrupt the process and it will take a time for them to continue with the process. So I think this is really a tough time for everybody. I'm quite sure that we will come up soon, and we will recover very fast.
Thank you so much, Sanjeev. I think on the lighter note, we also receive a lot of, I mean, we are a legal tech platform, so many legal advice seekers reach out to us with all their queries from various areas of law. The most surprising one was where one person had requested that how can he take divorce during this lockdown? And it is really, really necessary. So even the Times of India had reached out to us asking about which type of queries have increased during this lockdown. And when we actually looked at the database, nearly about the family law, especially the matrimonial law, approximately 20% increase in queries had come up, where people were relentlessly asking what are the options that we can take during this lockdown to. So that's on the lighter note, but yeah, there are many other areas of law that are rearing to go as the lockdown gets over, and even during this lockdown also the function is happening. Thank you so much. I think in the interest of time, we should take a few questions that our audience have been asking. So over to you, Sahil.
Thank you so much, sir. Thank you everyone for such a wonderful session. I mean, it was really insightful. So we have some questions from the audience. So one question for Aaron, sir. What would be alternate methods or communications or forums available by the service providers to demand for the long pending payment due from the customer instead of opting NCLT or litigation at this point of time? So you're on mute.
Yeah, I think you mute again, Aaron, I think.
Yeah.
Yeah, can you hear me now?
Yeah, we can hear you now.
Okay, so thanks for that. So given the, increase of the limit in the NCLT to 1 crore and possibly the new notification in terms of suspending all new filings in the NCLT, the few other options which we are looking at is one is summary suit. A summary suit is a civil suit. You file it in the High Court, and it reaches a summons for judgment stage. In Mumbai, you're getting to that summons for judgment stage, say within an approximate period of around 9 months. At that stage, the court decides if the claim can be disputed or not. If the court arrives at a view that there is no legitimate dispute to your claim, the court can immediately issue a decree at that stage itself. If the court takes a view that there is a legitimate dispute, the court will convert the same case into what we call a long cause or an ordinary civil suit, which will take several years for filing. So a summary suit is one of the remedies we're looking at. Second is, as in the past, arbitration is always advisable. I hope, most corporates and businesses put it in all the contracts as a rule. Under the new arbitration amendments, of course, arbitrations must get over within 12 months with a 6-month extension possible. That's the second alternative. A third, which not many people know about, is in case of small and medium micro enterprises, MSSMEs. There's a remedy available under MSSME Act, which is very effective. Any registered MSSME can file a complaint online with the MSSME Facilitation Council. The MSSME Facilitation Council, if it views it to be a legitimate dispute, can convene a mediation and can call both parties in, even if the other contracting party is not a MSSME, to come and participate in a mediation. And I've seen many and a surprising number of these mediations being quite successful. If the mediation is not successful, under the Act, the MSSME has the ability to convert this into an arbitration where it itself acts as the arbitrator or it refers it to a panel of arbitrators. So I think this is a very effective remedy, underutilized, and especially for MSSMEs.
Thank you so much, sir. I guess Hitesh sir has dropped off due to some urgency, but we are trying to reconnect with him. So we have another question. Can a contract be renegotiated if specific clauses are absent? Anyone from the panel would like to take this question? I'll just repeat the question. Can a contract be renegotiated?
So contract can be negotiated, Sahil.
Can a contract be renegotiated if specific clauses are absent?
So could I take that one?
Yeah.
Yeah. So okay. So I think all contracts can be renegotiated, but it's a question of maybe in a way discussing with a contracting party, saying either you agree with me in new terms of a contract or else. And the question always is, what is that or else? Is it that you go back to the original contract and back off from a renegotiation, or do you breach the contract, or is there something in the contract which helps you, which is shared with the other party or which only you know about? So the question is giving the other contracting party a choice on either to change the terms of the contract or else, or something else happens. And you've got to always consider what is that or else, and that's what gives you either leverage, advantage, disadvantage in entering into a renegotiation.
Okay, thank you so much, sir. Yes, Pawan sir, please.
I think the contract renegotiation is always open depending on what the new clauses they want to bring in, and how do those clauses impact both the parties, and if both the parties feel that those new clauses will be of mutual benefit in terms of, like if they have missed out something significant, and if they are fine with that, it should be easy to work on. But to Aaron's point, yes, if it is one-sided and somebody wants to bring in something only for his or its advantage, then that is something which the other side may got to agree to, or may have reservations on, and which might derail or delay the process of renegotiation.
All right, sir. So any other point on this particular question? Mukul sir, Sanjiv sir?
No. I was simply saying this, yes,
Okay.
the contract can be negotiated. It is between the parties. But then again, as rightly pointed out by Aaron, Pawan, that if what you're asking for is something which is completely different than what you've earlier agreed to, it will be difficult to why the other party will agree to it. But then again, it is all because it is all part of negotiations, and it is all the negotiation skill. Legally, anything can be done. A contract can be amended, can be negotiated at any point of time.
All right, sir. Yes, sir.
Can I add on something? So it is that negotiation should happen for a specific reason, and if any of the parties is of the opinion that we have skipped something, then they can start discussing with the other party, and when both the parties agree, then they can incorporate a new clause, or they can create a sideline agreement, supplementary agreement, or something like this. There could be a situation when there is a change of law, then that new clause can be incorporated into the contract, and something is somehow escaped the minds of both the parties, like for example the arbitration clause, and parties now feel that arbitration is an important thing, or at the time of getting into the main agreement, parties did not agree on something, subsequently they agreed on something on that particular aspect, then they can incorporate that clause also into that agreement. So it is very much open for the parties to renegotiate a contract.
Thank you so much, sir. So as per the time constraint, we weren't able to take more questions. So we will be putting up this recorded session live for the audiences, and you can provide your questions over there so that all the panelists can answer. So now I would like to hand over the screen to Purnima for a word of thanks, and really thank you so much for such a wonderful session again. Thank you so much.
Thank you, Sahil.
Thank you.
What us versus corporate really stand for? Thank you everyone for telling us what does it take and what are the real aspects. As Advocate Solomon Aaron just told us about and the scope post-pandemic, what can be done, in that context. Mr. Hitesh talked about aspects such as risk management, the new models, and succession plans that was retaken, again and again throughout the session that can be subsequently put into practice. We have had Mr. Shastry did discussion on the differential change and what we would think of as it seems as per the current scenario. Sanjiv sir talked about the ground reality as far as the system is run, in concern to the IBC, and how is it on ground with the courts. Mr. Pawan talked about the factors of impact and how is it different among different institutions. It might be corporates or startups or anybody else. So it was extremely insightful. And I, on behalf of our CEO, Mr. Himanshu Gupta, and the entire team of Lawyered and Lawyers Club of India, extend a very hearty vote of thanks to all speakers for gracing the event and sharing with us your findings and opinions today. The current pandemic situation has forced every business across the globe to adapt to the new way of operating commercially. A big thank you to our esteemed speakers for throwing light on the legal side of the situation and helping the community at large. The questions were, I think, very evident to anyone who is running a business today. Thank you so much to all the panelists, including Himanshu sir. So this is all for the audiences. If you have any follow-up questions or queries, of course you can put up the queries on our YouTube channel, wherever we are going to be putting the session. You can also write to us on info@lawyer.in. Thank you very much for your time, and we hope that you have a great weekend. Thank you.
Thank you so much. Thank you so much. Bye.
Thank you. Thank you, Himanshu. Thank you, everybody. Bye-bye. Take care.